Hi there, it's Tamara Doris, your Sacramento real estate professional and your Sacramento real estate professor. And today I'm going to talk about disclosures. Disclosures, disclosures, disclosures. You know, the old adage in real estate used to be it's location, location, location. I say that takes second place to the disclosure law. Disclose, disclose, disclose. So what are we going to talk about with disclosures? Here's the thing. Sellers think that if they make the property look as nice as it can without revealing any history or leaks or flooding or things that fell apart, that their property will be more appealing to the buyer. And on a conscious intellectual level, that is a good point. But here's the thing. The things that you don't tell a buyer that could end up later biting you in the bank account. And let me give you some examples and some clarity around the law in California real estate disclosure law. By law, the seller must reveal anything that is considered a red flag or legal term, a material fact. What is a material fact? A material fact is any information about the property that may cause the buyer to change their mind. That's a material fact. Anything that fits, and we've got so many disclosures, it's not even funny. And I'll go over a few. But anything that might make the buyer say, ooh, I don't want to buy this house. Well, as a seller, you might think, well, that is counterintuitive. That is counterproductive. I want to sell my house. I don't want to tell the buyer something that's going to make them not want to buy my house. But what happens when you fail to disclose is not pretty. First of all, if you fail to disclose something and the buyer finds out about it, because you failed to disclose it, even if the buyer didn't really suffer damages for the discovery, they can still sue you and they can make up damages. And I'm sorry, California is a sue happy state. So let me use an example, a real life example. Let's say that the seller failed to disclose that there had been pets on the property. And then the buyer finds out later that there were pets on the property. And now all of a sudden, whether it's true or not, that's not what I'm here to judge. All of a sudden, the buyer has this raging allergy to, say, cats, for example. And now they have to get the HVAC system completely changed because the cat hair got all up in it. And they have to redo the flooring because there was urine in the sheetrock. And I know people that this happened to, $25,000 later. And it wasn't an intentional oversight. It was just a non-intentional oversight. Okay, this is why I'll tell you, when you are selling your home, your agent has to do something called an AVID, Agent Visual Inspection, and Agent's Visual Disclosure Inspection. And what it really is where the agent, myself, walks around and looks for any red flags, any material facts. Now, I don't ask you questions when I do my AVID form. It's only my visual view. It's only my visual view. It's not me asking you questions. However, when you do the disclosures called the seller's questionnaire, the seller's personal questionnaire, and the transfer disclosure statement, it will ask you questions. It will ask you questions like, has anyone died here recently within the last 3 years? It will ask you questions like, have you ever had a flood? Have you ever had, has a floor ever been ruined? If this, all these questions. And please don't make the mistake of thinking, well, it's no big deal now. I don't have to say it. It'll be fine. Because I promise you, the odds of it somehow coming up are not enough that I would wager a penny on not losing it. In other words, I had a seller once who said to me, well, I used to have a really bad leak in the built-in swimming pool, but it's not even there anymore. So I'm not going to put that, right? Wrong. Because here's where disclosure law really, really slams sellers. Disclosure law assumes that if you as a seller didn't reveal it, there's more you're not revealing, and it's worse than it could be. And so the courts will favor the buyer, including the damages that the buyer says that they've suffered. So if someone said that they had a leak in the pool and and the seller knew about it and didn't disclose it, and then the buyer finds out that the seller knew about this leak in the pool, well, they could turn that into some big old thing. They could turn it into, oh, I had to go to therapy for 5 years. Of course, I'm exaggerating, but it is California, so things like that do happen. So just be really, really careful about thinking, well, it's fixed now, I don't need to disclose it. I had a listing in Folsom once. There had been a flood years ago, in the laundry room. That's not uncommon. The washers don't go over, blah, 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 blah. Everything was fixed and repaired, but they didn't think they needed to disclose it. It asked right on the form, has there ever been a flood in any of the rooms? You have to disclose it. If you don't disclose it and I don't know about it, I can't protect you. But if you just on that form, just check the box, and then it'll give you a little example. It'll say, explain what you marked for, 8C. And you'll say, 10 years ago, the washing machine overflooded. All repairs were made. That's it. But you have to do that, because what happens when the buyers move into your house, and if just one little thing that you didn't disclose, but you technically knew, they can get you. They can take you to court. And, the way that the real estate court works in California, it gets really congested. The Sacramento courthouse, it gets really congested with real estate lawsuits. And here's what can happen. Your property, your funds, like if you have funds, like you sold your house and the funds are wired into your bank account, and right away the buyer, says, no, this isn't right, your funds could be tied up for a year easily. The property could be tied up for a year. And I'm being minimal. I know that sometimes it's taken 5 years to settle a real estate lawsuit. So you are doing yourself a disservice if you think skipping over or not mentioning it is going to make a difference. People will find out. I'm not going to talk a lot about the death disclosure, but that's another example. You could say, oh, well, it says 3 years, so someone died here 3 years and 2 months ago, so I'm going to put no on that box. And then the new people move in, and then the neighbors say, oh, it was so sad when so-and-so passed away. And the buyer says, well, I thought there hadn't been any deaths in 3 years. Oh, well, it was about 3 years and a month ago. You think that buyer, depending on who the buyer is, isn't going to get upset by that, because they very likely might, because they feel like the seller tried to pull a fast one on them. And that's what it really is. Disclosure law, yes, there are actual damages that happen because a seller failed to disclose. That's true. I will agree with that. But more often than not, I believe that buyers feel like the sellers tried to pull one over on them, and then they get angry, and then they want revenge, and then they call an attorney, and the attorney will look at the document, the disclosures, and say, yeah, they didn't disclose this. Has it caused you any harm? And that's when buyers can get really creative. Oh, I've been having these migraines. I'm just saying, I'm not picking on buyers. I'm just saying that the seller is the one who is at fault for not disclosing. Now, when I do my form, the Avid form, as I said, I can only choose things, I can only talk about things on that form that I can see with my eyes. Let's say there's a big water spot on the ceiling. I can't say on my Avid form, big water spot, seller says was repaired, blah, blah, blah. That is not allowed to go on that form. All I can say is ceiling appears to have water stain. I can't give any explanation as to why or what or whatever. So the buyers have to sign that form, my disclosure, but they also have to sign your form. And what them signing your forms, your disclosures, says is, I am the buyer, I am aware of these past conditions, these problems, whatever. I'm aware of it and I'm moving forward. But if you don't put it on that form, and then the buyer can't sign, the buyer signs it, but it wasn't on that form, you're the one that's in the wrong. Do you get that? All the disclosures that are in California, which are more than I think any other state besides possibly New York, but we have a ton of disclosures in California. And I swear to you, almost every single one is based on a lawsuit that someone had before. So now we have to disclose it. Okay, the lead-based paint, 1978. If you have a property built before 1978, you have to disclose that there could be potentially lead-based paint. Doesn't matter if you have gutted the house and you've painted 100 times over. Doesn't matter. All you have to do is disclose that there's the possibility of lead-based paint. And if you fail to disclose that, and if the buyer moves in the house and they have a child who chews on the paint curls on the windowsill or some chipping paint, and then the child turns out to have, like, say, autism or something like that, they could blame it on you. And they would probably win if you didn't do the disclosure on lead-based paint. So think of the disclosures as a way for you to say, here it all is. Now, if you have any questions, let me know, but here it all is. You know, the good, the bad, the ugly, all the warts and everything. You have to do that to protect yourself. And, you know, when it comes to resale, you know, real estate is resale unless it's a brand new build. There's going to be problems with the house. There was a flood in this room. You know, something else burned down one time. There was electrical issues here. The plumbing had to be uprooted here. Things happen. That's just typical. It's typical, especially in older homes. But to not disclose it, I want you to get this, immediately puts you as the seller at fault because you failed to disclose. So do yourself a favor. If you're in California and you're going to list your home for sale, please do your disclosures to the best of your ability. Your agent only knows what you tell your agent. And a good agent is going to say, we have to disclose that. Okay? But to not disclose, you are setting yourself up for a lawsuit. And just because escrow closes and you're fine and you think, okay, I got away with it, it could come up, I mean, the statute of limitations, it could come up later. And you're still going to get in trouble for it. You still could get sued for it, okay? So we don't want that to happen to you. So the golden rule is disclose, disclose, disclose. Now, if you're interested in my new free home selling seminar, specifically for Sacramento, but it will work probably just about anywhere, please click on the link below and watch that. It's absolutely free. And if you have any questions about real estate or you're thinking of buying or selling in Sacramento, there's a link, set up a time, let's talk, and I will help you through the process. Hope you have a great day. Bye-bye for now.